Hey, this is Allie. I'm a corporate guide with Northwest Registered Agent, and I've been with the company for 2 years. Today we're going to talk about intellectual property. We'll talk about what it is, what is not protected, and common misconceptions. First, let's talk about what's included in intellectual property rights. It includes assets centered around human creativity and innovation. This includes trademarks, copyrights, patents, and trade secrets. Also books, recipes, songs, drawings, architectural blueprints, and marketing strategies. This is protected by federal and state law. If you want to use someone's intellectual property, obtaining permission is the safest path. Let's talk about what is not protected by intellectual property rights. Facts such as 2 + 2 = 4 are simply facts, and because of this cannot be owned. Ideas, unless spoken, written, or otherwise recorded, are not protected. While saying an idea aloud renders it protectable, unless it's recorded in a verifiable medium, this may be difficult to prove. Titles. The same title can be used for multiple movies, books, songs, etc. If a title is trademarked, it may be unavailable to use. Domain names. Unless domain names are trademarked, they are not intellectual property. For more about trademarking your domain name, check out our video linked in the description. Now let's talk about public domain. Creative work and inventions whose intellectual property rights expired, were relinquished, or were otherwise taken away. Once a work enters the public domain, it is free for anyone to use without permission. Next, let's talk about fair use. This is a U.S. law that allows for specific types of use of copyrighted materials or trademarks. For example, if the purpose is to comment, critique, or parody the intellectual property. It's worth speaking to an intellectual property lawyer to ensure the use is legal. Finally, let's talk about intellectual property myths. Number 1, patents have global rights. Patents only have rights in the country they're applied for. To extend protections, you need to apply for a patent in every country you wish to have protections. You can apply for a patent using the International Patent Cooperation Treaty, which has 150 member nations. Number 2, anything on the internet is fair game. Just because something is on the internet doesn't mean it's in the public domain. Most content online is protected by copyright. Get permission from the copyright owner before using the material for your own means. Number 3, I can post a cover of a song online without permission. Unless the song you want to cover is in the public domain, permission from the copyright owner must be granted in order to legally post it online. To use the song itself, you'll need to buy a mechanical license. If you post a video along with audio, a synchronization license is required. Number 4, content I created for my job is mine. When you create work for hire, it is the property of the hiring party unless a different agreement has been reached. Number 5, trademark registration creates trademark rights. Trademark rights are gained when a trademark is used in commerce. Registration significantly enhances those rights, especially when you register your mark at the federal level, but registration is not required to have rights in a mark. So today we discussed intellectual property. We defined it, talked about what isn't protected under intellectual property rights, and discussed some common misconceptions. Thank you for tuning in. If you found this helpful, give the video a like and subscribe to our channel. If you have a topic you'd like us to cover, leave it in the comments, and remember, call Northwest when you want more.